Good afternoon, everyone. Greetings. Welcome to our webinar today about protecting residents from inappropriate evictions in residential care communities. My name is Amity Overall-Lave, and I'm the North Director, and I'm going to run through a few housekeeping items before we get started with the discussion. Next slide, please. So I assume that most of you are really comfortable with Zoom by now, but just a few reminders. Please use the Q&A feature for questions for the speakers. And you can see how you get to that box. You can just scroll your mouse down on your screen, and there'll be a little chat icon as well as Q&A. So hit the Q&A icon and enter your questions. You can enter your questions anytime during the presentation, but we will hold questions till the end after all of our presenters have spoken. Use the chat feature to submit comments or respond to questions from speakers or other attendees. Please complete the evaluation questionnaire when the webinar is over. We'll plug that again near the end so you don't forget. And then just as a reminder, we are recording today's presentation, and the webinar recording and all materials will be available on the website shortly after our live presentation. Next slide, please. I hope that many of you attended our first quarterly technical assistance or TA talk in September. If not, you may be new to the certificates of participation that we're offering in hopes to assist programs in achieving in-service training or continuing education throughout the year. We are offering these certificates of participation for those that join our live Zoom trainings for at least 30 minutes. So you will automatically be issued a certificate, but you have to register, attend under your registration email, attend for at least 30 minutes, and the certificate that will be issued to you will include your name, the training details, and the amount of time that you were actually on that webinar. So you can share that with your supervisor in hopes to count for continuing education. If you have questions about the certificates, you can visit that link for the FAQs that we have available, or of course you can reach out to us directly. So we are very excited. We have a loaded agenda today with 3 excellent speakers that will share their experience and expertise regarding evictions in residential care communities. First, we'll have Eric Carlson, Directing Attorney with Justice and Aging. Eric has broad experience in many forms of long-term services and supports, including home and community-based services, nursing facility care, and assisted living facilities. He led Justice and Aging's extensive research on Medicaid-funded assisted living and currently is leading a project to assist consumer advocacy on Medicaid-managed LTSS in Florida and New Jersey. He counsels attorneys from across the country and co-counsels litigation on consumers' behalf. Up next, we'll have Amanda Scott. She is the Idaho State Ombudsman. Amanda is a social worker and has been the State Ombudsman for 2 years. Prior to that, she worked as an Ombudsman Program Representative for 8 years. Amanda has worked with seniors, individuals with intellectual delays, and individuals with mental illness. Molly Davies will be our final presenter today, and she'll share her experience as an Ombudsman Program Representative for a local program in California. Molly is Vice President of Elder Abuse Prevention and Ombudsman Services at Wise and Healthy Aging. She has oversight of Wise and Healthy Aging, the Ombudsman program at Wise and Healthy Aging, and the program is responsible for providing regular coverage to over 1,800 facilities that have the capacity to serve over 75,000 residents. So pretty big program. The objective of today's webinar is to share some federal and state legal tools and advocacy strategies to defend residents of residential care communities from inappropriate evictions. Eric will provide an overview of federal and state legal tools, and Amanda and Molly will provide some advocacy strategies, both individual and systems advocacy from the state and local perspective. As you know, residential care communities is now the term for board and care, assisted living, and similar facilities in the National Ombudsman Reporting System, or NORS. So that's why we've used that term. However, as you know, states use a variety of terms for the setting. So you will hear some of our presenters refer to these facilities as assisted living, residential care, or something else. But just wanted to be clear that we're all talking about the same type of long-term care facility. Next slide, please. So with that, I'm going to go ahead and turn over the presentation to Eric. Thank you, Eric.
Thanks very much, Amity. You can go to the next slide, please. Just a quick background on Justice and Aging. We're a national nonprofit that use our legal skills as lawyers to protect and benefit older Americans, particularly those with limited income. And because of that, our areas of emphasis include Medicaid, supplemental security income, housing, many other related areas as well, with a particular focus on populations that historically have been underrepresented. Next slide, please. So this picks up on what Amity was just saying. What are we talking about? Residential care, assisted living, adult foster care, personal care homes. The terminology is going to differ from state to state. And so because of that, it's a bit tricky to do a national webinar. We just want to be clear of what we can and cannot do. You're a little bit limited in being quite as directive as we might be, as I might be in, say, talking about federal nursing facility law, because in that case, we're talking about concepts and laws that are applicable from whatever state you're in. But that's not true in assisted living residential care, because with some exceptions, as I'll mention, we're talking about state law. The state law is the licensing law that sets the standard by and large for assisted living and residential care, and also, not including but not limited to the eviction standards that may be applicable. And as Amity mentioned, these facilities are going to be called different things in different states. Next slide. And the variation, though, isn't limited just to the name. There's variation throughout the standards that are applicable to these facilities. That being said, we can make some generalizations here. And I want to start to talk about some general aspects of assisted living because it's relevant to a discussion of eviction, or this broader question of who's an assisted living resident? When are you appropriate for residence in assisted living? On average, the assisted living resident needs less care than the nursing facility resident. But that's not as true as it was, that's not as true as it was 5, 10, 15 years ago. There's more variability now. And maybe 10 years ago, you could look at someone and say conclusively that this person is appropriate for a nursing facility and this person is appropriate for assisted living. That is less true now because you may instead look at a resident and say, well, this person could live in some assisted living facilities or maybe could live in a nursing facility instead. And indeed, we'll talk about federal Medicaid waivers for home community-based services that frequently pay for care in an assisted living facility. A condition of participating in those waivers is a need for nursing facility care or the equivalent. So for those people, explicitly, they are living in an assisted living facility, but their level of care needs are at a level that would justify Medicaid payment for nursing facility care as well. Next slide, please. And so over the last 5, 10, 15 years, you have seen across the states a greater ability by assisted living facilities to admit and retain residents. Maybe 10, 20 years ago, you saw many more explicit, rigid limitations on people who could or could not live in assisted living. If you go back far enough, if you couldn't walk without assistance, maybe you weren't allowed to be in a facility because of the supposed fire risk. And and you still see limitations based on healthcare needs, healing wounds, administration of medication, etc. But in general, these restrictions are not as restrictive as they have been in the past for a few reasons. One is that that's what consumers want. They don't want to be forced to necessarily to leave assisted living and move into a nursing facility when they instead maybe would be able to stay in the assisted living setting for months and years longer. In addition, that's something that providers would generally like. They don't like seeing their customers pick up and leave necessarily. And so it's in their interest in many cases to be able to retain or admit people with some non-trivial healthcare needs, for example. And in addition, from a legal perspective, the Americans with Disabilities Act and the Fair Housing Act has something to say about this as well. And there are some published cases brought against states that had explicit limitations, particularly I'm thinking about ambulatory requirements that were initially applied to certain residential care facilities, but were struck down by the courts because the judge, in looking at those requirements, found that they were unnecessary. They were more stringent than was needed to protect residents' health and safety. And because of that, they were not justified under the non-discrimination provisions of the Americans with Disabilities Act and the Fair Housing Act. Next slide, please. So what you'll see is, and this is where we particularly talk about things that are relevant to eviction. The level of care ceilings have been raised in a lot of states. So the facilities will have the ability to admit and retain people beyond the ability that they've had in the past. But in the eviction setting, you see this discrepancy that although sometimes the facilities may have what they perceive as the discretion or the ability to admit and retain people with these higher needs, they don't necessarily see that as an obligation to do so and may consider this more of a one-way street, that they have the ability, if they want to admit and retain people with these needs, but without, from their point of view, the obligation. And we'll talk about how that plays out as a practical matter. Next slide, please. It varies, like a lot of things, by state to state. There is more clarity in those states that have specific levels of assisted living, high, medium, low, or 1, 2, 3, however that's denominated in the states. When you have more explicit levels like that, you're more likely to have some clear delineation of what's allowed and what isn't in a particular type of assisted living facility. You will also, however, in a lot of states not have levels of care like that and just have one broad category called, for example, assisted living or residential care facility for the elderly. In those states, in those facilities, there tends to be less clarity because it's such a broad spectrum of care needs within just that one category of facility. And it's more likely that the level of care standards and the lines drawn within those standards to be set by, for example, admission agreements, or unfortunately by these ad hoc facility decisions. The facility just feels like they have the discretion to decide. And I want to point out here that that doesn't mean that consumers are helpless in these situations. There is some law that can be brought to bear in these cases, but I just want to point out that the facility may at least initially believe that they have complete discretion to make these ad hoc facility decisions. And that's the way it oftentimes played out, unless residents are are savvy enough and determined enough to dig in their heels a little bit and force the facility to retain someone, for example, or to provide a level of care that the facility would, given its druthers, prefer not to provide. Next slide, please. There's limited federal law. We have talked and we'll talk a little bit about the Americans with Disabilities Act and Fair Housing Act, which is relevant in some cases for establishing an obligation by the facility to accommodate residents' needs. In addition, I want to mention the limited federal law that is attached to federal home and community-based services waivers. And we'll talk about this in more detail at the end of my time. As I mentioned, many states have some Medicaid funding for assisted living, which is oftentimes provided through these Medicaid home and community-based services, HCBS waivers. For better, for worse, there's not a lot of quality of care standards that go along with that. There generally are some quality measures, but in my experience, they're not particularly transparent to persons outside of state and federal government and not particularly useful. By and large, the federal government gives the HCBS money. I'm exaggerating a bit here, but to make a point, but I don't think it's a huge exaggeration. The federal government gives the Medicaid money to the states. The states assure the federal government that the health and welfare of the Medicaid beneficiaries will be adequately protected and that state law is adequate in setting up meaningful standards. And the federal government accepts those assurances with no particular knowledge of or control over what the standards are. The one most prominent exception to that rule will be effective a couple years from now, this HCBS settings regulation, which now has been in process since 2014. And states have been in this long transition period to come into compliance with the regulations that are set up for the purpose of assuring that HCBS settings are not overly institutional. And that's the one exception really here from the CMS side, where the federal government has something to say about the quality of care provided in assisted living facilities. And I'll discuss that at the very tail end of this presentation. So next slide, please. Okay, the prime directive is, we'll reveal this, don't move out. We were talking backstage Zoom before the presentation started about this. And I think I can't emphasize this enough. If the three of us, the panelists, were talking about it, how important this is, how easy it is really to lose your case right off the bat just by panicking and moving. I think anybody who does this work sees this happen all the time. People who just, and I'm not disparaging our clients, the consumers. I get it. It's they are facing pressure that I'm not facing. They're being told by the staff that cares for them that they have to leave. There's various assertions as to the law, which they don't know are true or not, and they have to fight this general sense that if these people don't want them, maybe they shouldn't be there. But it's oftentimes incredibly counterproductive. And the one thing I can say for certain, if you just move out, you have lost your eviction case. And if you come to me or anybody else 2 weeks later to say, I regret it now, I think these facility people weren't doing the right thing, what I'm going to say, or what my counterpart's going to say is, too late. This is not the time to raise those issues. The time to raise those issues was when this was a live dispute. And as we'll discuss here, you just don't want to underestimate your leverage. Again, I know it's easier for me to say that as a lawyer, as opposed to someone living in a facility, but you really don't want to underestimate it. If you, in a lot of these situations, just stay put and you don't have to be a legal genius, but just say to the facility, I disagree. Right? I disagree. I'm going to assert whatever appeal options are available to me because I believe that what you're asserting is not true, or what you're asserting doesn't justify my eviction. And in so many of these cases, just that simple step's going to make all the difference. Next slide, please. So let's take a look at some specific facility claims. Next slide. The common eviction justifications. I'm going to spend my time here today just talking about 1 and 2. The facility can't meet the resident's needs and non-payment. Those are the most common. But because this is state law we're talking about, there could be some others as well. Certainly, it varies from state to state, and there's some odd ones, and particularly some ones that are not resident friendly at all, particularly the first one listed in blue. I know I've seen in some state regulations, just a simple statement, if the facility serves a notice saying your tenancy is ended in this facility, the resident has to leave. So in some of these, they're very broad. They give the facility a huge amount of discretion. Don't have time to discuss them individually today because they're state specific, but I would just mention that if that's the sort of thing that's in your state law, you want to think about some systemic advocacy ahead of time so that facilities don't have this broad discretion to just force people out. There need to be substantive standards more meaningful than that. Next slide, please. It can't meet the residents' needs is a common issue. In some states, the facility is asserting something particular that's laid out in the regulation. There'll be specific criteria in the state reg that says you can only stay in the assisted living facility as long as you do not need this, that, or the other thing. Examples listed here of insulin or healing wounds or pressure sores, or I'm sure you're all familiar with these sort of criteria. And in these cases, for better or for worse, it's more specific. You know exactly where the battlegrounds are, and as the attorney or advocate, you need to prove that in fact the resident does not need insulin injections or does not have a stage 3 pressure sore, whatever the issue is. In addition, there may be, in some cases, a potential claim against the state saying that whatever that specific limitation is inappropriate under the Americans with Disabilities Act. But I recognize that's a heavier lift requiring litigation and not just appearance in some sort of administrative process. Next slide, please. And going on with this discussion of cannot meet your needs, oftentimes the issue will not be a particular regulation that lays out this specific unacceptable or inappropriate condition. And I would submit that these type of arguments are more common. It's not that the state law says that this particular condition can't be accommodated in a facility. It's just that the facility says, in a broader, more ad hoc sense, we can't meet your needs. Example listed here, the client has dementia and requires too much staff time, or again, anybody who's listening to this webinar has probably heard multiple variations on this. You want to push back on these. It's, to a certain extent, this is similar to some of the kind of arguments you'd make in a nursing facility setting, although with slightly less ammunition. In a nursing facility setting, you have the advantage of pointing to the really strong provisions of the federal law that says the facility has to do all these steps necessary to get the resident to the highest practical level of functioning. here you could look at state law and see what you could find. There is likely some language in the state regulations that talk about meeting residents' needs and maintaining independence and you know, providing assistance with activities of daily living or whatever it is. Look at the state law, look at the admission agreement to see, maybe look at the advertising from the facility, the representations that they've made about the wonderful services that they provide and their ability to assist people as those person's needs shift. Or also, you can argue on the facts as well. You know, what is the resident's condition? What sort of care does the resident need? And ideally, again, similar to how you work in a nursing facility eviction situation, try to get out of an eviction framework and into a care planning framework, right? Have these discussion with the facility. It is about culture change. It is about meeting residents' needs. What can be done to address whatever the problem is? And here there may be some Americans with Disabilities Act relevant arguments as well, talking about just a general obligation to accommodate a resident's needs, rather than the facility just throwing up its hands and say, well, there's nothing we can do. Instead, pointing out that, in fact, there is something you can do. You can do this, that, and the other thing. And that's the kind of accommodation that the ADA arguably requires in situations like this. Next slide, please. And then we move to non-payment. Discussion here, probably a little quicker and a little bit more focused because we're talking about money and there's less discretion about, less argument about whether it's paid or not, because it either is or it isn't, but for a couple of arguments that you should be familiar with related to public benefits like SSI and Medicaid. If it's private pay, it's dependent upon the admission agreement. Make sure that the admission agreement actually authorizes the charges that the facility has asserted here. Sometimes facilities just feel that they have discretion to set rates rather how they choose, and to do various add-ons depending on the resident's needs. But if they're doing that, it should only be when the sort of add-ons or additional charges, a la carte pricing, for example, are authorized by the admission agreement. And also, as I mentioned, and so in those cases, the private pay basis, you're really looking at the admission agreement, what the resident has agreed to pay, what the facts are, and what the facility can justify given the admission agreement and the resident's needs, and whatever assessments, for example, that the admission agreement might refer to as far as, for example, setting a particular tier of services that the resident needs. Next slide, please. Make a couple of statements here about public benefits, that in some states, there will be some specific law dealing with SSI, with supplemental security income. And by definition, a resident's income, when the resident is eligible for SSI, is limited. A state regulation will likely limit the facility's ability to charge a resident more than a particular percentage of his or her SSI payment. And just as a practical matter, there's just not that much money there. The facility, is just limited on a practical level from charging any more than the resident's limited income. The facility may attempt to get quote unquote supplemental payment from a resident's family member and friend, but those may well be inappropriate depending upon state law. And so look askance at any efforts by the facility to get payment that supposedly quote unquote supplements SSI. It shouldn't be the the obligation of a resident's family members and friends to pay on top of SSI instead. And again, this varies from state to state as to how strong the law is here, but oftentimes there are some provisions that limit a facility's ability to bill on top of whatever the SSI allocation is. Next slide, please. And let's have a relatively quick discussion about some Medicaid eligible, some Medicaid relevant rules as well. I would suggest to you that you should not let facilities enforce any kind of agreement to pay privately for a particular period of time. These are duration of stay agreements. You can move on to the next slide, that have been unfortunately common over the years, and they're contrary to this Medicaid provision, which applies across Medicaid and prohibits a Medicaid certified provider from charging a Medicaid beneficiary anything more than what's allowed. And so, I mean, this you can't charge a Medicaid eligible person as a private pay person, for example. If just obvious example, if a physician cares for someone who's Medicaid eligible, the physician, if the physician is certified to accept Medicaid, has to bill based on Medicaid and can't charge the person a private pay fee-for-service rate. It's just, you have to accept the insurance. That's the standard for a provider for participating in these programs. Next slide, please. Some nursing facilities or assisted living long-term care facilities more generally over the years have not been particularly good about this. And this goes back decades in the case of nursing facilities, but had policies that told residents that they would accept the resident's Medicaid, but only if the resident paid privately first for a specific period of months or years. It's called duration of stay because there'd have to be a set duration of stay before supposedly the facility would be willing to accept Medicaid from that person. That's explicitly barred by the federal nursing facility law. That makes it clear that if a facility can't charge a Medicaid eligible person anything more than the designated Medicaid rate, the patient pay amount, to the extent there is one. Next slide. But you see this in assisted living, unfortunately, and in some states seem to just recognize it as the way things are. I would just encourage you to not accept that. It should be a violation of law for the same reason that the doctor has to accept Medicaid from a Medicaid eligible person. Assisted living facility should be following the same protocols. Next slide, please. And so if and when you see these situations, I just have to warn you that the system in your state, right, may just assume that that's the way it is, but I think that's wrong. And so feel free to consult with us or with other people when you see this, because we do need to push back on that. And I think for obvious reasons, just quickly, you understand the unfairness of it. You have a situation potentially where a person is in an assisted living facility. The assisted living facility participates in Medicaid. The person spends down their life savings, becomes Medicaid eligible, and then the facility says, well, we're not taking Medicaid from you because we haven't gotten enough private pay money for you. It's should be a violation of the federal law. And if and when you see situations like that, I encourage you to not just accept that as a done deal, but to consult with us or talk to other people or see what might be done in that instance. Next slide, please. Which moves us on to the procedural question. Next slide. Just talk about the different procedures which are going to vary from state to state. In adjudicating evictions in residential care situations, you may be looking at the landlord-tenant law, just a standard eviction trial in the state trial court, some sort of administrative hearing in a limited number of states, or potentially nothing. That you see some states, in my experience, where there may be some criteria for transfer discharge for eviction, that some state regulations, generally skimpy, that authorize eviction under a limited number of circumstances, but that don't specify a procedure of any sort. Next slide, please. And administrative hearing, that's relatively self-explanatory and easy to understand. That there's going to be provisions in the state regulations that describe the notice that's required and the steps that are necessary for the resident to get a hearing in front of an administrative law judge or someone similar. In a lot of states, however, you'll see instead a specific reference to landlord-tenant law, or, as I mentioned, in many cases, a reference to nothing, which requires the advocate to assert that that there should be a remedy in landlord-tenant law, because there has to be some kind of remedy. It doesn't make a particular sense for the facility to just have the absolute right to be judge, jury, and executioner on these cases. And in many cases, that kind of fairness argument is supported by the language of the landlord-tenant law, which may broadly apply to all dwelling units, or the language changes from state to state, but the language tends to be very broad, and to be broad to an extent that may well include residential care facilities, assisted living, those types of settings. Just want to make a point here to say that residents shouldn't necessarily be spooked and scared away by the landlord-tenant law. It's more expensive. Again, it's more complicated. It's a lawyerly process that's more formal than the administrative hearing process. But that cuts both ways. It's less attractive for residents. It's less attractive for facilities as well. And the burden is on the facility to file the case. In these administrative settings, the burden is on the resident to appeal, where in the landlord-tenant setting, the burden is on the facility to start the process and get a lawyer and file the case. And oftentimes they just aren't willing to do that. Next slide, please. And so, again, don't underestimate your leverage here. I get why it's difficult, and I do understand the benefits of the administrative hearing process. It's much simpler. It's much more accessible. It doesn't intimidate people as much. But if you're in a situation where it seems like the eviction trial is the likely route, in some cases, it makes the don't move out option even more powerful, because if the resident just stays put and says, I disagree, you can meet my needs, or I have paid the bill, whatever the argument is, then the ball goes to the court of the facility, which, and they may not be particularly eager to file an eviction case and deal with that, because it may be just as unfamiliar to them, or close to being just as unfamiliar to them as it is to the resident. So next slide. And this will just very quickly talk about the HCBS settings regulation here. It won't be effective until March of 2023. And states have been developing transition plans. And when it is effective, next slide, please, the relevant provision is this one, that to make sure that these are not overly institutional settings, the federal regulations require that the resident, in a minimum, has the same protections against eviction that tenants have in that state, and the state must ensure that at a minimum, there's a written agreement that provides protections that are equivalent to those that tenants have. Next slide, please. And again, it's not effective until March 2023. So the advocacy at this point is involved in working with the state rather, to make sure that the transition plan is adequately robust. A lot of the transition plans that I've seen just repeat the regulatory language, and ideally there'd be something more than that. So with that, I move on to the next slide, and I will transfer the conversation, I think, over to Amanda to talk about some of the specific work that she's done.
Thank you. Do you want to go ahead and turn my video option on?
Sure. Just give me 1 second. Okay, you should be good.
Thank you. So COVID certainly has been a teacher in so many ways to us this past 18 months. We've learned how to use some technology that we didn't previously know, but along with that, there's been a lot of other opportunities for growth for us. Next, please. At the onset of COVID, I had only been the state long-term care ombudsman for 6 months. And though running for my life sounded like a safe option, it was not a probable option. And when you can't run away, the option left is running towards and embracing the problem. But my path was riddled with obstacles to resolution. Up to COVID, I felt I had a pretty good working relationship with licensing. And my view of them was that they are there to make things right for the residents. I was a frequent caller as a local ombudsman and thought they were pretty much the option available to us to make changes to issues and facilities. COVID provided a different view altogether. Facilities were not expected to keep residents if they left the facility or were non-compliant to what the facility wanted to do.
Hi, this is Amity. I'm not sure if you can hear me, but it looks like we're all asking the same question, if Amanda lost sound or if our screens are frozen. And so we're trying to figure that out, and we will get right back on. Just one moment.
I can hear you, Amity, so it may be Amanda.
Okay, good. So I'm glad you could hear me.
Yeah.
I'm not sure if anyone can hear me too. Okay. Then if it's okay with you, Molly, can you go ahead and jump in, and Katie, fast forward to Molly, and then we'll work on finding Amanda.
Sure.
Absolutely.
Thank you.
Sure. There we go. Thank you. Okay. What's a webinar without a little technical difficulties? Thank you for having me. I'm Molly. I'm from Wise and Healthy Aging, and I administer the Long-Term Care Ombudsman program in Los Angeles. Next slide. And Wise and Healthy Aging is a nonprofit that provides an array of mental health and social services for older adults and their caregivers in Los Angeles. And our long-term care ombudsman program, we serve both the city and the county of Los Angeles, and we're the sole provider of such services in LA. Next slide. So I'm going to talk with you a little bit about an issue that came up in our community and has been something that's been going on in our community for a while now. And during COVID, it was actually an opportunity for us to work on a special project to address it. So what we were seeing was that residents from both skilled nursing and residential care facilities or communities were sometimes being discharged inappropriately to homeless shelters. And we were finding out about it every now and again, but knew that we were only scratching the surface. So one of the things that we really wanted to do was to do some outreach so that we could learn about the problem from the shelter's perspective, and also so we could provide education to the homeless shelters about what they could do about it, and really to direct them to bring referrals our way so that we could help make better transitions for our clients. So how we got started, we started kind of just raising awareness about this issue in the homeless services community. So kind of inviting ourselves to the table, which ombudsmen are generally good at doing. And we just started showing up. I just started showing up to different events and talking about this issue. And as I was talking about this issue, homeless service providers were saying, yeah, this is an issue. So offered to give a training on this. Next slide. So we created a training and then also adapted a resource guide. So the training was called, and the slides, if you wanted to adapt them for your own community, are going to be made available. So you can, edit away and customize them to your needs. But it was called Elders and Disabled Adults Just Discharged to Homeless Shelters from Long-Term Care Facilities, because we were covering both skilled nursing and residential care communities. We also created a long-term care facility transfer discharge guide for homeless and emergency shelter operators and advocates, which that guide will also be shared with all of you, and you can, you're welcome to use it and customize it for your state. We collaborated with the Corporation for Supportive Housing, who was hosting trainings for over Zoom for homeless shelters in Los Angeles. And so we thought, what a great way, rather than going shelter by shelter, was to reach this wider forum. And CSH is a national organization that focuses on training, education, lending, policy reform, consulting, and technical assistance for housing individuals who are experiencing homelessness. So you may have a CSH partner that you could reach out to, and I'm happy to get you connected if I can through my contacts at CSH. They've been wonderful partners. Next slide, please. So first we want to talk about how was this at all relevant to the work of a homeless services provider or a homeless shelter operator? And so the session really provided tools to help those individuals advocate for their clients. So to identify if a client was inappropriately sent to shelter by a long-term care facility, and what do they do about it when that person reaches their door. We also wanted to help make better transitions for clients to and from long-term care facilities. So if a homeless shelter received somebody from a facility that they really couldn't care for because they hadn't had care and supervision needs, they had medical needs, what they would do is they would call 911. That creates another transition that of course we were also trying to avoid during COVID, not have inappropriate transitions to hospitals, if at all possible. So we came in and said, if the client came, you know, if you get a hold of us pretty quickly, we can help negotiate them back into that facility rather than having you call 911, have them become hospitalized, and then get placed at some point. So we wanted to create another option for folks who were inappropriately placed in shelter from a long-term care facility and not just send them through the 911 system. And then we also wanted to help clients who may have had a bad experience or were discriminated against at the long-term care facility. So it was another avenue for us to generate information about concerns that our residents may have in long-term care facilities. Next slide, please. So what was the purpose of the training? We really wanted to train them on basic transfer discharge rights of residents in long-term care facilities so that they had a really broad understanding of what those rights are. So the training is pretty specific, and it is for the skilled nursing side, it would apply to all states, but for the residential care community side, that's going to be California specific. But we really wanted them to have an overview of and to know that these clients they were receiving actually had a lot of rights. We wanted to provide them resources for what to do if the facility sends somebody who needs care and supervision to them and the shelter can't provide it. We do have a handful of shelters that do provide a little bit of a higher level of care than others. So there's a few outliers, but many of them are just not equipped for that. We also wanted them to know what to do if a facility said that the resident left against medical advice. So we had discussions about that, and we really wanted to learn from them. Next slide. So I'm going to give you just a brief training outline. So we went over the long-term care ombudsman roles, responsibilities, issues addressed, and process, so that they had an understanding of what to expect when working with us, talking about consent and confidentiality and all of those things, so there's no surprises. We list the collaborations that we had with other agencies to help them see that we were working with some of their other partners and establish our credibility with them. We gave brief definitions of what the different long-term care facilities were and who some of the residents were, the age and some of the conditions they might have, very, very briefly, so they had an understanding about these different settings. We don't want them to be experts, but we want them to have exposure to. We talked about the facility obligations to residents during discharge, outlined the legal reasons for both skilled nursing facilities and residential care communities, transfer discharge reasons, and then what to do if a facility transfers a resident to the shelter, from something as simple as how to negotiate the person back in, to making formal reports and appeals, including referrals to the Ombudsman program. When in doubt, refer to the Ombudsman program or call us and consult with us was our messaging. We explored things like self-determination, cognitive impairment, and again, leaving against medical advice. We have this thing that happens very commonly where a facility say the person left AMA and really they went on an outing against medical advice, but they didn't transfer or discharge out against medical advice. So that's become a hot button issue for us here in Los Angeles. We started exploring when somebody has a bad transfer to a homeless shelter, what to ask that client to get at the root of that if it was a choice or were they pressured, et cetera. So we have actually a whole list of questions that we prepared for the homeless shelters so that they could kind of interview their client and see if they needed to call us or not. And then when is it okay to transfer someone to a homeless shelter? So we did also talk about that. Next slide. And this is just the cover of the Elder and Disabled Adults Discharged to Homeless Shelters from Long-Term Care Facilities Guide for homeless and emergency shelter operators and advocates, which will be on the website.
There we go. Thank you, Molly.
You're welcome.
All right. Thanks especially for jumping in all of a sudden like that. And thank you all for bearing with us. Like Molly said, it would not be a webinar these days without some kind of snafu with IT. Okay, so let me see here if we can get Amanda on the line. Unmute herself. Okay, Amanda, can you hear me? And if so, can you unmute yourself? You may be able to, since you should have the panelist call-in information. All right, I'm going to hit allow to talk, see if we can try that now, and ask to unmute. Amanda, can you hear me?
Yes, can you hear me?
All right. Yes. Hi. Great. Thank you for your flexibility. That's okay. It's happened to all of us. So, you know, got to keep us on your toes. All right. So the floor is yours. Thank you very much.
All right. Thank you. So I'm not sure when I froze up, so I'll go ahead and just start with some of the things that were options for me that I seen. First of all, I spoke with the manager of the Residential Assisted Living Facility Survey Program at Health and Welfare. And my conversation with her, I provided her with my concerns that I had concerns that we would see an increase in eviction discharges from assisted living facilities. My concern also was that we would see an increase in the community in both the homeless shelters and in the crisis centers, which are mental health crisis centers. So my conversation with her, after speaking for about an hour, it didn't go very far. She just kept notifying me that facilities do have the right to discharge. They do have the right to discharge. And I understand that. My concern was that we need to have an option in place to meet residents' needs when they are unsuccessful within the facility that they are in. So I left that meeting with the issue unresolved. So I set up a meeting with our legal counsel, which is through the Attorney General's office. And the information or response that I got from them was that Health and Welfare takes guidance, gives guidance to the governor's office. So he did not feel that I would be able to place something in, put something in place similar to what Michigan was able to prevent evictions from facilities during the COVID crisis. So I left that meeting with the issue unresolved. And I reached out to legal aid and we discussed the issues that we were beginning to see here in Idaho, the increase of evictions from facilities. And facilities were told that, yes, they were able to evict, and if a resident left a facility and came back during COVID, that they could meet the resident at the door and provide them with a written eviction and not readmit them in. And legal aid was, they were quite appalled with what facilities were doing. So through our meetings, we went ahead and thought it would be good to broaden our outreach to see if maybe there were others that we could get to work with us to advocate in resolving these issues. Could you please move to page number 3? So the answer to my desperation was for us to reach out to Intermountain Fair Housing, to Disability Rights Idaho, along with Legal Aid Services. Idaho has had a history of facility-initiated discharges for a long time. And there's been a tolerance of these evictions by facility licensure through the Department of Health and Welfare. At the onset of COVID, these concerns were increased due to the increase in discharges. Next, please. So one of the first things we did after reaching out to these agencies was in 2020, we put together a seminar, and we presented it during Residents' Rights Month. And it was on residents' rights with a focus on evictions and discharges. And we discussed our understanding of the regulations. And it became really evident that each one of our agencies, we came from a total different perspective of the regulations and law. And I learned so much from these ladies. And as a team, we brought together HCBS requirements, state regulations for residential care facilities, state statutes, Fair Housing Title 8 and of the Civil Rights Act, and those rights for individuals with disabilities, both physical and mental. And one of our focuses became on facilities providing reasonable accommodations for these mental health disabilities. And next slide, please. So with working together with our partners, we were able to put some tools together from our collaboration. We have put together a discharge, eviction, question and answers, a letter to facilities, letter to residents, a poster for facilities, resident information document, and also along with the PowerPoint presentation that not only our office shares, but also our partners share when they have calls in regarding evictions or discharges. And this has provided us with some additional tools. But I think the greatest tool that has come from this has been the continued collaboration and referrals from our partners. Next. So benefits of each of these programs will be different in each state. Idaho is based on landlord-tenant. So at first, that really was, it was an obstacle to us. But it has been, through assistance with our partners, it has become it's been something that now that we're able to work better with. The benefit to our program has been the momentum of the combined energies of these programs as we have worked together to build a team. Idaho, working with Idaho Legal Aid Services has expedited the response to evictions. So we work with Idaho Legal Aid Services, and what we have found is they can, when they become involved and present that, they have an open case to a facility. We have seen that it has been to the residents' benefit to have them involved. Some of the benefits have been that family and residents will pursue a legal suit once the resident has moved from the facility, or that they work with legal aid to prevent or slow that process down. One of the things that has kind of been a liability or a weakness in the Ombudsman program is often we do not receive the notification of eviction or discharge prior to an individual already leaving the facility, and family have then called us to reach out to let us know that they had been evicted and these are the circumstances. But when we have the opportunity to have that knowledge beforehand, we are able to reach out to legal aid services, and with that first contact, the greatest benefit that we can hope for is when the facility rescinds that eviction. Next. Referrals to Intermountain Fair Housing Council for representation related to reasonable accommodations in the event of an eviction notice. It has been, it's been a tool that the Ombudsman program has been able to use. And similar to working with legal aid, we are also able to slow that process down of the eviction or discharge so that the Ombudsman are able to work on that with the facility, work on that eviction to be able to find appropriate placement for a resident, one of their preference rather than to be sent to a homeless shelter, a motel, or the crisis center. And similar to legal aid, the best that we can hope for is really that the facility rescinds that eviction. And each one of these programs work from a legal basis. So through legal aid, fair housing, and disability rights, they are working with lawyers. And sometimes just the simple fact that a facility, especially an assisted living facility, receives a notification from their office that they have an open case on this situation, sometimes that's enough that the facility will rescind that eviction. Also, Intermountain Fair Housing will file complaints on behalf of residents and families with HUD or assist in obtaining an attorney to file in state or federal court. Next. Working with Disability Rights Idaho, they have been an amazing advocate for residents against discharge and eviction. They have been a great form of education, and they also go into facilities and investigate complaints and they've been a good tool for us to use for evictions. So I think the main point is that I would like to share is that each one of these programs, whether it is legal services through your state and fair housing and disability rights, they look through a different window, and they have expertise of their own regulations and rules and what facilities should and should not be doing. And it is a knowledge based on your state, which is also an advantage to you. I myself cannot speak highly enough of our partners and the benefit that they've been to us, and they receive complaints into their offices that prior to COVID, we were not receiving notification on, but they are more, they reach out to us more to assist the clients that they receive, and they are always number one on our list when we get that immediate eviction or an unwanted eviction that we are not able to work with the facility and resolve. They have become an amazing tool for us. So I'm grateful for the opportunity to provide this information. And if you do not have a good working relationship with these programs, as when I came on as state ombudsman, we really did not have a lot of working relationship with them. And due to COVID, it really has been a necessity and definitely to our advantage in more ways than just evictions and discharges. And working as a team, if it's been unsuccessful individually, working as a team to resolve issues has definitely been an advantage for Idaho. So thank you.
Thank you so much, Amanda. And Katie, if you'll go ahead and fast forward to the resource slide. Thank you. All right. So before we get into questions, I wanted to share a couple reminders about resources. Next slide. As you heard Amanda and Molly speak, they talked about a lot of resources that they created, flyers, PowerPoints, letters. So thanks to Molly and Amanda, they did share those with us to share with you as part of the webinar resource package. So they will all be available. Sorry, I'm hearing an echo. They're all available at the link in this slide, and that's the same place that we'll put the webinar recording after today's presentation. So just as a reminder, we will share the link to these materials to all the registrants as well as our entire listserv. So thanks again for sharing those. Next slide. And just as a reminder, we do have a page dedicated to residential care communities / assisted living facilities. So that is that link as well, and you'll find some resources. As Eric mentioned, and I know I talked about briefly, it is challenging to provide a webinar on a national forum on residential care communities just because there's so much variety throughout the country. So we're always open to sharing successful practices and advocacy strategies that you have in your state, or just examples, especially on how to address evictions or any other issues. So please continue to share those with the Resource Center so we can share them with your peers. Okay, next slide, Katie, please. And let's roll into questions, which we had quite a few. So if you'll give me a moment to toggle over to that. Let's see here. So one question likely for Eric. Which federal regulation makes duration of stay agreements unlawful for assisted living? And you may need to unmute if you haven't already.
I'm just,
Or you deep in thought.
I'm finding it now. That's my excuse. I'm thinking that it's Title 42, Code of Federal Regulations 447.15, and it's the general provision that says that a Medicaid provider has to accept Medicaid as payment in full. And again, if anybody has any questions about this, feel free to contact me, ecarlson@justiceandaging.org. It's this is not a slam dunk, and so it's not firmly established. But I stand by the description that I made during the webinar. It's something that we need to assert on behalf of these residents.
Thank you, Eric. And we'll make sure to include that as a resource link in the materials after the webinar as well. So you have a direct link to that. So another question that we received quite a few times about hospital dumping, which of course, we usually speak to that related to nursing facilities, but this of course happens in residential care communities as well. So the folks asking this question are looking for any advocacy suggestions on how to address this situation in this setting, since there's not as, of course, as federal requirements or guidance that you could use.
Yeah, I think so. The standard disclaimer here, it's going to vary from state to state, blah, blah, blah. But beyond that, I think what you'd argue would be that you've got a tenancy. I think even more than a nursing facility, you've got an argument that you paid for your room for the whole month, right? And particularly if landlord-tenant applies, then it's even clearer. So in residential care facilities, I think it's even more of an understanding that you're not paying day by day. You've paid for the entire month, maybe a month in advance, and just the same way if you paid for your apartment, you got the right to go back there. Now, me saying that is one thing. Making it happen, getting back in is something else. And I get the distinction. Will the licensing agency help you? Maybe not. If they do, great. And I think that's the argument that you may make, that I paid for it. I got to be able to go back. These guys just can't cut off my tenancy because they feel like it. Also, you may want to seek a court order. Again, easier said than done, but you go to a judge. The same way if you were an apartment tenant and your landlord locked you out, you go to the court. You say it's an illegal lockout, and judges understand that. They completely understand that, and that's a common fact pattern for them. And they, in a situation like this, I think are more than ready to rule against the landlord in this case. So that I think is a option as well. Just a quick plug for our own stuff. We, Justice and Aging, released a toolkit on eviction. It's focused on nursing facilities. This was something we released just a couple of weeks ago. But it includes sample court pleadings, a complaint, and requests for temporary preliminary injunctive relief that could be adapted to a residential care facility setting. So for you lawyers on the line, I point you to those as a starting place, so you wouldn't have to start entirely from scratch, possibly.
And one additional thought, we use the same approach, Eric, in California, and One of the things we tell our clients is, our residents, if they're in the hospital, make sure, and it's about time to pay the rent, make sure you pay your rent. Because sometimes we see facilities discharge people at a certain period of the month, hoping that they're not going to pay rent, and then they'll have less to stand on when it comes time to return from the hospital.
Thank you. Thanks, Molly and Eric. Those are really, really solid and practical tips that folks can use immediately. Thank you. So one more quick question, and then I want to go to some additional slides. And I believe this one is for Molly. And I received a few comments like, wow, I didn't know they were discharging to homeless shelters. So I am glad that that's not happening in some areas in the country, but unfortunately we have heard of an uptick of this in the last few years, both from nursing facilities as well as this setting. So the question is, Molly, sadly, most of the residents in these facilities may not know what an ombudsman is, simply due to the number of these facilities and then the few ombudsmen. So if they were discharged to a shelter, does the ombudsman program find out from the shelter that a resident was discharged there, or is the facility required to report the discharge to some kind of governing entity?
Yeah, so in a residential care community in California, they are not required to report it to anybody. So we would find out about it from the shelter or from the resident or a family member. That's why we did this outreach, because this is a really hard population to get at. And it's a very vulnerable population. And it's probably one of the more egregious types of inappropriate evictions. And hence the need for that robust outreach. For if it's a skilled nursing facility, they are supposed to, the nursing home's supposed to send those discharge notices to the Ombudsman program. They're not required to send them to the regulatory agency, but that was a mandate that was given or a requirement given without additional funding. So for example, in the Los Angeles program, we get over 60,000 transfer discharge notices a year and rising, and not all of our facilities are even doing the appropriate reporting. So again, a really, really hard issue to get at, and needing to have that collaboration with the shelters.
I could not agree more. We're hearing that across the board as far as volume and the demand and the needs that are there. So that I took a few notes while folks were talking, and as I was seeing chats come in, and a lot of them, as Amanda spoke to the point of sometimes the Ombudsman program, even in the cases of nursing facilities that they're federally required to give copies and notices, they may not receive the notice until after the resident has left because of that pressure. And same thing with residential care communities, they may not know of the program or be required to send that notice. So I think this really speaks to a need for more proactive consumer education about their rights. Mm-hmm. So perhaps with a lot of the COVID relief funds that state and local programs are getting, I strongly encourage you to not recreate the wheel. Why don't you look at the resources that we'll share with this webinar that the speakers talked about, but really think about how you can do some more proactive consumer education to make sure they know their rights. Maybe it's quite simply, do not move out, over and over and over, and then how to contact your program. But just a thought as far as proactive communication to address this. Secondly, our presenters briefly touched upon looking at any kind of contracts that the facilities may have with the resident, landlord tenant, looking at paying your rent, great tip. Also encourage you as an ombudsman to make sure to look at whatever admissions agreement they may have, so you can look at the policies and procedures regarding evictions. So whether it's an admissions agreement or contract or whatever it's called in your state. So with that, I do want to go through our last few. Katie, if you can go to the next one. And then I'll take over the screen after this one. So before I talk about one resource that I neglected to include in our resource section, I wanted to see if anyone on the line during the webinar today is new to the Ombudsman program. And if you are, welcome. And if you are and haven't visited this page that's linked on this slide, I encourage you to do so. And if you're not new, you've been with the program for years, but you train either paid representatives or volunteers, please send them the link to our new Ombudsman representative page. It includes this infographic here to help them get to know the Resource Center and how we can support them in their work. So I encourage you to do that. Let me see, Katie, I'm going to go ahead and see if I can share my screen. So just a moment, everyone. Okay, so this is the resource that I completely neglected to include in my slides. I apologize. But a lot of the questions that we did receive were about nursing facilities. And since we were primarily focused on residential care communities today, I just wanted to highlight this issue page that we have about transfer discharge. The majority of the resources here are specific to nursing facilities. And if you have not looked at this toolkit, as Eric mentioned, Justice and Aging just put out a fantastic toolkit as well. This one we published last January, or this past January, and it is really comprehensive. The idea behind it is to introduce new representatives to some advocacy skills related to discharge, and then of course provide a refresher to those that are more experienced. You can even use this as a training tool. As you can see, we have the comprehensive guide as a PDF, and then we broke up these individual charts that you can print out as well. So we have a basic complaint investigation process checklist, and then we have all these different charts based on the reasons for discharge, including some prompts that you should ask during your advocacy and some action steps, as well as the legal basis for those action steps. So I encourage you to look at that resource if you haven't already. All right, now let's see if I can get back to my slides. I'm really testing out my skills or lack thereof during this webinar. Slideshow. There we go. All right, can you see the join our mailing list slide? I hope so. This is just to remind you all.
Sorry.
No?
No.
Okay,
Yeah.
let me do a new share. Thank you, Katie. Let's see. There we go. All right, now can you see it?
No. Do you want me to pull it up? Oh,
Yeah.
just kidding. We can see it now. Sorry, just took a second.
Okay, good. Yeah, it takes a while from out here, I guess. But anyhow, if you did not receive information about this webinar directly, then you're probably not on our mailing list. So please sign up. This is how we share information about webinars, training opportunities, but also our new resources that we create, our quarterly e-newsletter and our monthly NORC notes. So please join that list. And some events, obviously, you are probably well aware that this month is Resident Rights Month, but just wanted to put that plug there and encourage you to share any activities that you're doing during the month with us. And then next week is the Consumer Voice Conference. It's virtual and registration is open, as well as information, of course, about the conference with the agenda, if you haven't seen that. As a reminder, please provide your thoughts about today's training. Your input matters. So there will be an evaluation that pops up as soon as we close out the webinar. Please just take a few minutes to fill that out. All right, and here is our contact information. We have a Facebook page, Twitter, and then we even have an app. So if you don't have the app yet, please download it. The idea behind that was to provide you some tools while you're out in the field right at your fingertips. So I want to give a huge thank you to, of course, Eric, Amanda, and Molly. Thank you very much for sharing your time with us, your expertise. I think we've all learned a lot on this important issue, and we still have, based on the questions that came in. Thank you for sharing all of them, and I'm sorry we couldn't get to all of them. I think we still have a lot more room and opportunities for training on this topic. So thank you very much. Thank you, of course, Katie and Carol, for doing all the important back-end work on this webinar to make it happen. So very much appreciate that. Thank you all for spending your time with us this afternoon. And like I said earlier, you should receive a certificate of participation shortly after this ends. And we hope that that helps you in achieving some of your continuing education. So thank you all for the important work that you do. And I'm going to go ahead and close out for today. Let us know if you need anything, and please keep us in the loop about the great work you're doing out in the field. So take care. Thank you very much.